Our programs in legal studies and human life studies give out awards to distinguished scholars and those who've made contributions on behalf of the church in those particular areas. And today we're going to make one such award. As interim chairman of the Department of Humanities and Catholic Social Thought, which includes those two programs, legal studies and human life studies, I've been asked to make this presentation today. And the award reads the following. In recognition of his scholarship, pro-life advocacy, and his leadership of Ave Maria School of Law, directing its mission to educate a new generation of lawyers, judges, and politicians to integrate faith and reason in natural law jurisprudence so as to better serve the society, the church and civil society, President and Dean Eugene R. Milhizer is hereby awarded, well, it's two awards round up into one, actually. The St. Thomas More Distinguished Jurists Award and the Our Lady of Guadalupe Pro-Life Advocate Award. It's my great pleasure to be able to present this award from our programs to Dean President Milhizer here today.
I hope that I'm speaking to some future students here today. I would be happy to meet with anyone who has an interest in law school generally or about our law school. And you also have a great resource here, Professor Brian Scarnecchia, who's here in the front, who is a professor at our law school on leave of absence this year at your university. And I know Brian would also be very happy to talk to anyone who might be interested in law school generally or Ave Maria School of Law. The subject of my talk today will be the Department of Health and Human Services mandate requiring employers to provide insurance coverage for contraception, sterilization, and abortifacient drugs. The mandate, as it was originally designed, required that all employers provide these products and services to their employees, even if the employer is a religious institution that opposes such practices as a matter of faith, morals, and religious doctrine. The only religion-based exception recognized by the mandate is extremely narrow and applies in essence exclusively to churches. Thus, under the mandate as it was originally designed, Catholic hospitals, charities, universities, and Catholic law schools like Ave Maria School of Law would not be exempted from the mandate and thus would be forced to provide morally objectionable products and services for its employees. In fact, it has been contended, correctly I think, that Jesus Christ himself and his apostles would not be exempted from the mandate as they ministered to people of many religious traditions. Before proceeding further, I should pause for a moment to explain what the term mandate means in the context of this issue, at least. A mandate is not a law, that is, it's not legislation that was passed by Congress and signed by the President, nor is it a policy statement or a guideline that merely encourages compliance. Rather, it is a requirement imposed by a non-elected bureaucrat, in this case the Secretary of Health and Human Services, based on authority delegated to her by Congress, which compels adherence under the penalty of law, in this case under the penalty of a substantial fine. One final point of clarification, the mandate that I will be addressing today, the HHS mandate, is different than the Obamacare mandate, which was argued earlier this week at the United States Supreme Court. The Obamacare mandate requires individuals to purchase health insurance. The HHS mandate that I'm going to address today says, as I said earlier, that religious organizations are required to cover contraception, abortifacients, and sterilization for their employees. Before discussing the various aspects of the HHS mandate and the so-called accommodation, I must initially say a few words about the characterization of contraception as preventative health care. Keep in mind, this is how the issue has been framed by those who propose it. That is, should religious institutions and organizations be required to provide preventative health care in the form of contraception to their employees. In response to this deceptive characterization, I would first observe again that the mandate extends beyond contraception and also includes abortifacient drugs and sterilization. But even leaving this aside, it cannot be fairly said that contraceptive services in any way constitutes preventative health care, except insofar as they are provided for an ostensible purpose of addressing a serious underlying medical issue that is unrelated to contraception. As my friend Jennifer Kimball has explained, because pregnancy is not an illness or disease, the prevention of pregnancy cannot be considered preventative health care. After all, when a doctor treats a pregnant woman, his professional training says that he has 2 patients rather than a single patient with a disease. Also, contraceptives themselves are harmful. Besides the serious harm that can sometimes be caused directly by the use of contraceptives, studies show that women on contraceptives are more susceptible to STDs because contraception compromises their immune systems. Indeed, one might even argue that if the government was truly interested in promoting preventative health care, then as a matter of consistency, in addition to raising insurance premiums to cover contraception, they would also require the same type of coverage for smokers. Finally, and more broadly, and while I'm certainly not advocating this, and let me be clear that I'm not advocating this, if the government was really concerned about protecting and subsidizing so-called reproductive rights, then one would assume that it would require coverage for in vitro fertilization as well as contraception, which of course it does not. As these brief observations should make clear, the characterization of the HHS mandate as being concerned with preventative health care for women is false, it's cynical, and it's designed to obfuscate the real issues that are involved. But even assuming, for the sake of argument, that the HHS mandate is actually concerned with preventative health care, the fact remains that its requirements are categorically wrong, morally and legally. The mandate is morally wrong because it obligates institutions, be they Catholic or not, to engage in activity that is immoral and intrinsically evil as a matter of natural law, apart from any religious teaching. It is fundamental that to deliberately kill children, whether they are born or unborn, is contrary to the natural law. Nothing could be clearer. Further, it is contrary to the natural law to sterilize people to prevent reproduction or to contracept using artificial means to accomplish the same purpose. To compel someone to provide such services against their strongly held convictions, especially religious convictions, is doubly immoral. All of this is obvious, and I'm sure for this group needs no further elaboration. It is likewise abundantly clear to faithful Catholics that the services and products required by the mandate are contrary to Catholic moral teaching. You may have heard that former Speaker of the House, Nancy Pelosi, has argued that since most Catholics who were surveyed said they have used contraceptives, that the Church's position on contraception lacked legitimacy as a religious teaching. Others have urged that the Church should change its teaching about contraception in response to the views of so-called enlightened Catholics. This is really a breathtaking argument, isn't it? Church doctrine, of course, is not determined by popular opinion or dissident theologians. For example, even if most Catholics who were surveyed said that it was permissible to miss church on Sunday, and some dissident theologians agreed with this, this shared opinion would not justify repealing the third commandment. Church doctrine is certainly not determined by government edicts based on opinion polls. Herein is a major distinction between religious and civil authority. Religious authority comes from God, while civil authority comes from the consent of the governed and the process by which that consent is expressed and implemented. That said, I'm sure that even with respect to civil authority, Ms. Pelosi would agree that if most people thought it was reasonable to drive 50 miles an hour in a 25-mile-an-hour speed zone, that doesn't change the legal speed limit. And again, all of this should seem obvious, and I won't elaborate on it further. I will, though, pause for a moment just to emphasize that the religious and philosophical objections to the mandate are far broader than any parochial Catholic cause. As Pat Gillen of our law faculty has recently observed, and I'll quote here, "A wide range of Christians who do not agree with Catholic teaching have publicly decried the mandate as tyrannical. Members of the Jewish faith have noted that it smacks of the oppressive European laws that proscribe ritual practices called for by the Jewish faith, and one of the witnesses who testified against the mandate before the House Judiciary Committee was Asma Uten, a Muslim woman. Likewise, this is not a feminist issue, as one can see by reading the open letter to the President that can be found at the Women Speak for Themselves website. Finally, this is not an issue about spending taxpayer monies. The government spends vast sums to make contraception available to women here and abroad. The mandate dictates how private institutions spend their own money." And I just conclude by mentioning that Governor Mike Huckabee, who is a Protestant minister and also a former presidential candidate, has said in regard to the HHS mandate, and I'll quote here, "In this matter, we are all Catholics." For the remainder of my presentation, rather than expanding upon why the mandate is morally wrong, I would like to spend a few moments addressing why it is legally wrong. In other words, why it is unconstitutional. I would note that in my judgment, the mandate also violates the Religious Freedom Restoration Act, or RFRA, but I will limit my comments here to the mandate's constitutional infirmity. The First Amendment to the United States Constitution provides, and I'll quote here, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of people to peaceably assemble, and to petition the government for redress of grievances," end quote. It is not coincidental that the very first right protected by the Bill of Rights is religious freedom. Freedom from an established religion and freedom to freely exercise religion. It's a sad fact that we have seen erosion over the past several decades of the constitutional protection of religious freedom in the name of honoring the Establishment Clause, which was originally intended to prevent the establishment of a government religion, something I think everyone agrees with, but has since been misinterpreted by the Supreme Court to prohibit the government from doing anything that can be said to favor or support religion generally. For example, the Supreme Court has concluded that to avoid establishment of religion, public prayer must be extremely limited, displays of the Ten Commandments are problematic, and manger scenes need to be accompanied by an exhibition of non-denominational elves and reindeer. That's a bit of an exaggeration, but unfortunately not too much of an exaggeration. On the other hand, though, the government and the courts have generally been more respectful of the free exercise of religion when the Establishment Clause is not directly implicated, insofar as they have resisted imposing requirements upon religious institutions which would force them to violate their religious beliefs. It has been widely understood that to do so would deny the constitutional protection of the free exercise of religion by unduly burdening that right, at least in the absence of some compelling government reason to require a religious institution to violate its tenets. For example, minors have always been permitted to receive the blood of Christ in the form of wine, even during Prohibition. Over our history, the government has rarely intruded upon the free exercise of religion, at least in a fashion that is as blatant and extreme as the HHS Contraception Mandate. And while my presentation today is not political in nature, I must say that the Obama administration has been particularly disrespectful of religious expression. Even before the HHS mandate was announced, the Supreme Court decided the Hosanna-Tabor case. In that decision, the court recognized a ministerial exception to employment discrimination laws, saying that churches and other religious groups must be free to choose and to dismiss their leaders without government interference. The Obama administration argued in that case instead that it didn't matter if the dismissed employee worked for a church or a labor union or a social club or any other group with free association rights protected under the First Amendment. The position was soundly rejected by the court with a 9-0 decision. And the unanimity of the court is just plain remarkable, because it's hard to get the 9 justices to agree upon anything, let alone a First Amendment issue. In the Hosanna-Tabor case, Chief Justice Roberts wrote that, and I'll quote here, "The result argued for by the Obama administration is hard to square with the text of the First Amendment itself, which gives special solicitude to the rights of religious organizations." And the Chief Justice continued, "We cannot accept the remarkable view that the religion clauses have nothing to say about a religious organization's freedom to select its own ministers," end quote. The HHS mandate represents a similar type of assault on the free exercise of religion. This time the government, rather than selecting religious ministers, is instead picking and choosing which religious doctrines must be violated by a religious institution. There is no precedent for this. In fact, the precedent is just the opposite. In response to the withering criticism of the HHS mandate from a variety of sources, the Obama administration announced a so-called accommodation. And under the accommodation, all insurance providers would be compelled to provide contraception and other objectionable services and products for free to religious institutions. The administration argued that this approach avoids any compelled violation of conscience or religious beliefs, as the religious organizations would not be funding the objectionable services. The accommodation is objectionable for many reasons. I'll limit my criticism here to 2, one that's factual and one that's legal. Factually, are we really expected to believe that private companies will provide products and services to consumers for free? Products and services that the government claims are very costly, without trying to recoup these expenses from consumers in some fashion? Of course they won't. Insurance premiums will be raised, and other revenue-generating measures will be undertaken by the companies to make up the difference. Think back to the ways in which banks have tried to recoup revenues lost when the government put limits on what they may charge for certain services, or the way automobile companies pass on to consumers the costs of mandated safety features. When the cost of the mandate's ostensibly free contraceptive products and services are eventually passed on to consumers, among their numbers will be religious organizations. As a factual matter, therefore, the accommodation solves nothing, because religious institutions will continue to be compelled to fund morally objectionable products and services. As a legal matter, the accommodation lacks any legitimate basis. And this is not an overstatement or hyperbole. I know of no constitutional authority, nor to my knowledge has the administration offered up a purported constitutional authority for compelling a private company to provide a product or service free of charge because the government deems it to be beneficial. Under the same rationale, I suppose the government could order that mammograms and prostate exams should all be covered by insurance companies at no cost. Perhaps we just ought to eliminate the middleman, and the government can dictate to doctors that they must provide these products and services for free. Likewise, in the name of preventative health care, a wide range of private companies could be compelled to provide, for example, free vitamins, or organic food, or orthopedic shoes, or exercise equipment. And why should the approach be limited to the medical realm? Aren't car seats beneficial? Well, then shouldn't the government require car manufacturers or seat manufacturers to provide them free of cost? How about burglar alarms to homeowners? How about better insulation and radar testing, cell phones, safety glasses? The list is literally endless. With the so-called accommodation of the HHS mandate, the government has in fact compounded its disregard for the Constitution and conscience and its contempt for free enterprise by ostensibly seeking to mitigate an undue burden on religious freedom by imposing an undue burden on private companies. This is serious business. Unless the mandate and the subsequent accommodation are defeated, Catholic institutions like your university and Ave Maria School of Law are left, in the words of Francis Cardinal George, with four terrible choices. One, secularize yourself by breaking connections with the church, which really, if you think about it, is a form of theft by the government. Two, pay exorbitant annual fines to avoid paying for insurance policies that cover contraception and abortifacients and sterilization. Three, sell the institution to a non-Catholic group. Or four, close it down. At our law school, the only option would be to pay the fines. But we will have a six-figure price tag as things presently stand, and the government could always raise that. And the cost is morally and legally objectionable and outrageous, and in the long run, it might be economically unsustainable. I'll conclude my remarks by observing that the fight over the HHS mandate is not a fight of our choosing, nor is it a fight that was inevitable. Rather, it is a fight that was thrust upon the American people and the Catholic Church by the Obama administration and the Department of Health and Human Services. And while we didn't provoke the fight, neither can we shrink from it. I believe the administration has seriously underestimated the depth and strength of the American people's religious convictions and respect for the Constitution. I likewise believe that the secular forces behind the policy have underestimated the influence and persuasive authority of a mobilized Catholic Church. In the end, I believe that the American people will insist that the mandate and the accommodation not be allowed to stand. I can assure you that Ave Maria School of Law will continue to engage political leaders and the broader culture to help achieve this most important objective. Thank you very much for your attention.